Welcome back to the legal video series presented by the Law Office of Joseph Abrams. I'm criminal defense attorney Joseph Abrams, and I answer your most common questions about federal criminal law in easy to understand terms. So let's take a look at today's question. The Bill of Rights constitute the first 10 amendments to the U.S. Constitution. Among these amendments, 4 of them speak directly to protections afforded to all criminal defendants. The 4 amendments include the 4th, 5th, 6th, and 8th. Let's take a look at each and see what they say. The primary protection afforded by the 4th Amendment is the protection against unreasonable searches. Its foundational principle is that the government may not arbitrarily violate a person's reasonable expectation of privacy, thereby requiring a warrant for most searches. However, there are exceptions to the warrant requirement. These include where consent is given, where a search is conducted incident to a lawful arrest, where exigent circumstances exist, and where property is in plain view or has been abandoned. The remedy for evidence obtained in violation of the 4th Amendment, known as the Exclusionary Rule, is that the evidence is excluded from criminal proceedings. Now let's take a look at the 5th Amendment. The primary protection afforded by the 5th Amendment, made famous by the Supreme Court case Miranda v. Arizona, is the right against self-incrimination. That is, the right to remain silent and not testify against yourself. Other protections afforded by the 5th Amendment include the right to indictment by a grand jury, a prohibition against double jeopardy, and the right to due process. Now let's look at the 6th Amendment. The 6th Amendment provides 2 very important rights. These include the right to a fair trial and the right to the effective assistance of counsel. This means that for indigent defendants, the court must appoint counsel for the defendant at the government's expense. Finally, let's look at the 8th Amendment. The 8th Amendment famously protects against cruel and unusual punishment. The vast majority of 8th Amendment jurisprudence, of course, deals with whether or not the death penalty constitutes cruel and unusual punishment. Throughout our history, rightly or wrongly, the death penalty as a punishment has been ruled constitutional. However, many related issues, such as methods of executions and inequality of its application, have raised serious constitutional concerns and continue to do so and are still litigated today. In closing, I simply want to add that the Bill of Rights makes the United States criminal justice system one of the fairest in the world. However, we can also acknowledge that it is not perfect and that defendants' rights are commonly abused. The best way for defendants to ensure their rights are protected is to choose an experienced criminal defense attorney who understands these rights and is able and prepared to demand their strict adherence. This has been criminal defense attorney Joseph Abrams. Thank you for watching and listening. I hope you found it helpful, and we'll see you next time when I answer another of your questions about federal criminal law. Thank you.